We are recording. All right, so at this point, I'm going to turn it over to Loveneet Bains, our instructor for the day. Loveneet is an escrow officer with Team Cutka and is our youngest escrow officer, but you would not know that by her vast experience and how much she has leaned into some of the challenges that escrow can present, especially when it comes to vesting issues. So I'm going to turn it over to Love.
Right. Thank you, Jennifer. Hi, everyone. So we're going to be going over the different ways to hold title, the different things that can come up during your transactions. I can tell you some horror stories at the end if you would be interested. So we'll just go through all the slides, and if you have any questions, you're welcome to type them into the comments box, and we can also address them at the end of the presentation. So,
all right.
Ready, Jen?
I'm trying to click. There we go.
Okay, so one of your best practices that you can do before heading to one of your listing appointments is to pull a copy of the current deed. Whenever I get requests from customers through an email asking for a copy of the deed, I will usually pull actually the last 3 deeds because I like to see how everybody came into title, because sometimes as you're going through the chain of title, somebody could have came off, somebody could have came on. You want to make sure that when you're going to your listing appointment, you are dealing with the correct people. I know a lot of people, they pull the tax records, but pulling an actual copy of the deed is actually the best practice that you can do, because sometimes the tax records don't show all of the names. And it can also show, the deed will also show you if they hold title in the name of the trust name, the date of the trust. So you can get all those details off of the grant deed. You're welcome to ask for a copy of the deed from any of the escrow officers that you work with, our customer service desk, Gail, or any of your sales reps. All of us have access to be able to pull this information relatively quickly for you too. So, always ask more questions up front if the person that you're talking to about listing the home is different than the person who's actually in title. That actually does happen quite a bit. For example, if there's a trust in title, then if the trustors, the people who created the trust, if they have passed away, then usually it's children or any successor trustees would be the ones that you would be talking to. When you run into that situation, we'll talk about trust a little bit more in a bit, but getting a copy of the trust documents is something that is required by our title department, and for us to make sure that we're having the correct people sign on behalf of the trust. And once you have secured your listing, you're also welcome to go ahead and pre-open your escrow with us. You can ask us, all you have to give us is the property address and your client's name, so that we can also verify that that's who's also in title, that's the person that you're talking to. And then, we can also start getting ahead of the game and clearing up any title issues that may arise before you even sell the property. Alrighty, so in California, there's a couple different ways that you can hold title. For example, for married couples, you can hold title as community property or as community property with right of survivorship. In California, it's a community property state. So what that means is whatever is your spouse's is yours, and what's yours is your spouse's. So that comes all the way down to liens and judgments as well. So if your spouse has a lien against them, then that is something that you would have to deal with through the escrow process. Community property with rights of survivorship, that portion of it means that if something were to happen to your spouse, the property automatically transfers over to the surviving spouse in the event that someone were to pass away. Whereas community property by itself, you can have the property transfer over to your spouse, but you also have the option to be able to delegate within your will or a trust that you wish for your portion of the property to go to someone else. Married couples can also hold title as joint tenants or as tenants in common. Usually people will pick joint tenants. We always advise our clients to discuss the best way to hold title with their CPA or their attorney. Sometimes there can be tax benefits when the customers hold, depending on how the customers hold title. Everyone's tax situation is different though, so we never advise the customer exactly how they should hold title. We do give them the various options and then people pick accordingly. Joint tenants means that if you hold title with another person as joint tenants, your interest would automatically transfer over to the other tenants in title with you in the event that something were to happen to you. Whereas tenants in common means that you have an undivided interest, and if something were to happen to you, your portion stays there and you have to go through probate in order to clear up, in order for any successors to your estate to lay any claims to your property. So the probate process can get pretty expensive and lengthy. It's all based on, the pricing is based on the size of your estate. So it just depends. I'm not sure of what the exact costs are, but I do know that attorneys have told me that it's based on the size of your estate. So certain, based on like the value of all of your assets, so your home, bank accounts, things like that. Most people do though go ahead and will hold title as joint tenants if you're married. And then the other way to do it is in the name of your trust. So a trust is its own entity. Usually when the trustors, the people who created the trust, are still alive, they associate their social security number or as their tax ID number. So they're essentially one and the same, but a trust is its own entity. So for example, I have a trust, and any property that I take title to, it's going to be in the name of my trust. If something happens to me, I have people who are already designated to sign on my behalf. I already have that all laid out. That way my family doesn't have to go through probate in the event that something is to happen to me. So they can come and sell any property that I have. If I were to pass away, they just have to supply the title company with my original death certificate and my trust documents to prove that they are the successors that are to sign on behalf of my trust. So the other way that people can hold title is if one person wants to go into title, but you are married. So you would hold title as your sole and separate property. When this happens, when you have only one spouse going in title, the other spouse does have to sign off on the property. And I actually just had a signing get canceled because the spouse refuses to sign off on the property. So a good question to ask those of you who represent buyers, when you have someone who is buying by themselves, ask them, are you married? And give them that heads up, because there's a lot of people who say like, well, I'm going in title by myself. Why does my spouse have to sign? It's because California is a community property state. And when it's community property, it's not necessarily our requirement, because we can proceed without having the customer sign. In cash transactions, we typically can do that. There's a lot of times though where a lender will require for the spouse to sign off and remove their community interest. On our side, we can show community interest on the customer's final title policy, but a lender does not usually want for someone else to have an interest in the property. So they will typically require for the customer to sign off on the property. And they do that by signing an interest also deed. So that's just something to keep in mind for those of you who have customers who are married and are going in title by themselves. To make sure that they are aware that the other spouse is going to have to sign off on the property. Alrighty, so registered domestic partners, you can hold title as a registered domestic partner. You can do it, usually the people will do it as joint tenants or as tenants in common. Each person can have their own interest, or you can go in title as joint tenants. Alrighty, unmarried couples. So the same will apply for unmarried couples is you can hold title as joint tenants or tenants in common. You can't hold title as community property because community property means that you're married. So unmarried couples can pick between joint tenants or tenants in common. Again, joint tenants being if something were to happen to you, then your interest automatically would transfer over to the other tenant, whereas tenants in common, you have an undivided interest. So your interest is yours. If something is to happen to you, your family, your relatives, they would go through probate to deal with your interest in the property. All right, so family members. Family members can also hold title as joint tenancy. I've seen where couples, they will, sometimes there's parents and children holding title together. We do usually have everyone sign an agreement that they understand that they're going to be holding title as joint tenants, just because we need to make sure that they understand that if something is to happen to them, their interest does automatically go over to the surviving tenants. You can also choose, though, to hold title as tenancy in common. So again, undivided interest. Or you can hold title in the name of someone's trust. The trust can also designate beneficiaries. So when a property is sold, there can be an allocation for what family members are to receive which portion of the proceeds. I do have a slide about proceeds that we're going to talk about here in just a little bit. Alrighty, so again, joint tenancies are an equally undivided interest. That's with tenancy in common. And you can each hold title with various percentages. So this is where, again, we would advise everybody to talk with their accountants to make sure that they are holding title with the correct percentages. If there aren't any percentages allocated when you sign the deed, then there is an assumption that it's each 1/3 interest unless we are told otherwise. And there are times where people will tell us, well, no, I have a 2/3 interest and somebody else has, the other person has a 1/3 interest, and that's completely fine. We can deal with that through the escrow process when it comes to dividing up the proceeds. But typically, if there's 3 people in title or 4 people in title, we just divide each interest equally amongst all of the parties. Never put a minor on title. If you decide to put your children in title and you go to sell the property, there has to be a conservator appointed for the child. So anyone under the age of 18, unfortunately, cannot be in title. This is where you can talk to an attorney about setting up a trust, because then you can have the trust distribute and hold money for a child up until a certain age. But yeah, don't ever put your children in title. That'll create a big mess at the end, and you'll have to get a conservatorship for someone to sign on their behalf.
Love, there was a question posed that what are the procedures or requirements when a married couple is in title, but only one of the spouses was on the loan and that same spouse dies and the surviving spouse wants to sell the property?
So I just want to reiterate that. So 2 people are in title, but only one person is on the loan?
Yes.
Okay, so if that happens, you can still sell the property because you're in title. And that's another thing that we do a lot through escrow is people will say, I do want to add my spouse onto title, and that's fine with us. Any people who go on title are considered buyers to the transaction. So if only one person signs the contract in the beginning, but we want to have the spouse added to title, we can do that. The other person would also need to sign the contract and be added on as a buyer. If you have a spouse and you do think you want them to go in title with you, we always advise to do it through escrow, because then both of you are covered when it comes to your title insurance. When you start signing deeds and transferring property outside of a title company without a sale or refinance transaction, you end up giving away a portion of your policy. So that's why it's always good to do it all through escrow, have the spouse on there, even if they aren't on the loan. When it comes to selling the property, the spouse who is in title would be able to sell the property. We would need a copy of their death certificate, and then the spouse would need to provide the mortgage information. With some banks, the mortgage companies will allow for us to obtain payoff statements with just the customer social. We can go through an automated system and we don't really have to communicate with anyone at the bank. But if they require written authorization, that is where you would need to reach out to the bank and assist with helping getting the spouse who is in title approved to be able to obtain information about the loan. Our job is to clear title, and one of the things that we have to do if there's a loan is make sure that the loan gets paid off in full, and we require to get a payoff demand sent to us directly from the mortgage company. So the only issue that you can potentially run into is that because there's the person who's on the loan has passed away, we may need a written authorization. But usually by sending in a copy of the deed that shows that the other person is entitled, along with the death certificate, the spouse can get approved on the loan to be able to ask for information about the mortgage. So the main thing is just to be able to get a payoff statement. And again, a lot of these banks that we deal with, they will allow for us to get a payoff statement through an automated system on the phone.
So Love, just staying on the family member's question for a moment, how tricky can it get when, let's say, siblings inherited a property and go to sell, and so you're technically dealing with 3 sellers that are in title and may not be in agreement on the terms and things like that? I know we can't decide, but what are some of the things that can either help or hurt if it's that type of situation?
So when you have property that is inherited, unfortunately, when it comes to the sale transaction, all of the parties do have to agree on the sale of the property and the terms of the agreement. I personally actually have had a client not too long ago where it was the wife's property, and her new husband was one of the beneficiaries to her estate, and then her children from a previous marriage. So the new husband and the children from the previous marriage did not get along. And we ran through quite a bit of problems throughout that transaction. They were in agreement with, the terms that the buyer had presented initially, but then when it came throughout the transaction, when they asked for repairs, when it came to how the proceeds were to be divided, how much money the husband had put into the property versus the kids, when it came to all of that, they all had to come to an agreement. They actually each had attorneys involved. So it can get pretty messy when you have multiple beneficiaries that are involved. That's why if you set up a trust before you pass away, you're the one who's in charge with delegating who gets what and who has to sign. So you could even have anybody sign for your trust for the benefit of other people. So for example, I'll give you a personal example. Within my own trust, my brother is one of the first beneficiaries in my trust. I'm not married, I don't have children, so my parents and my brother would be the first ones to be the beneficiaries. However, I have one of my best friends as my trustee, because she's the trustee before my brother is, because she's actually here in Fresno, so she would be able to easily sign paperwork. Whereas my brother, he is traveling, he's going to medical school, so having him sign paperwork isn't ideal all the time. It would be more of an inconvenience. So having her as a trustee, but he's the beneficiary, he gets all of the money, any profits from selling properties, things like that, but she's the one who signs for him. So that's why setting up a trust is really the best way to go when it comes to things like this, because then you really do avoid any disputes later on with what is supposed to happen with the money, how things are to be divided, because you were the one who was in control with deciding that before anything happened. If you're entitled by yourself and somebody passes away, then you go through that probate process, as did this family where it was the husband and her 2 children from another marriage. But then throughout the process, it was kind of difficult because they all had to come to an agreement, and there was some banter back and forth about how to get to that final agreement as to how much money people were going to get paid, who was going to pay for what. So unfortunately, though, at the end of the day, all of those items do have to get hashed out through the escrow process.
And then we have an agent asking, they have a listing where the woman owns the property as unmarried, sole and separate. She recently remarried and now she is selling. Does the new husband have to sign a quitclaim or other type of deed for her to be able to sell the property?
No. So one of the other things about California is that if you acquired property prior to your marriage, that is still your separate property. Now, if she holds title as an unmarried woman, but then she takes out, let's say, a line of credit against the property, and the husband signs on the loan, then he technically has an interest in the property. So if we see something like that, then we would require for him to sign. But if it's her separate property from prior to the marriage, and she's the only one in title, she is the only one who has to sign. The husband does not have to sign anything.
Awesome.
Okay.
All right, let's move on.
All right, so anyone who's added onto title must deed off of title. One of the things that I can talk about with this is with life estates. So if somebody reserves a life estate to a property, they are technically a seller. They have a right to the property. So that's where pulling a copy of the grant deed is very important, because it will show you who holds title and how they hold title. Somebody can hold title as to a life estate. Essentially, they're reserving the right to be able to live in the property, but they do have to sign a deed to remove their interest and relinquish any interest that they have in the property. If you have a spouse or any other party that you add onto title after the fact, after you purchase the home, there's a lot of people who contact us. They say, hey, I want to add my wife. I want to add my boyfriend, my fiance, my friend, whoever. You can add people, take people off as much as you want, but you will run into essentially clouding your title, because any liens against that party that you added on or someone who you took off can still technically attach the property. So as a title company, one of our things that we do is, in addition to clearing the title of the property, we have to clear the client's names of any liens or judgments. When it comes to sellers, we have to clear their name of any and all judgments that are filed and recorded in the county in which the property is located. So if you're selling in Fresno County, we search Fresno County records. If you are selling in Fresno and you have liens in LA or in LA County or in San Bernardino, in any other county, then we don't look for those liens. We don't search for those. I do run into that problem sometimes with lenders where there's a child support lien recorded in another county. We can try to search for it, but we don't pick up on those things unless it's recorded in Fresno County. So that's something to just keep in mind. And if you have someone who, if your spouse has a lien at the time of when they sign off on the property, or anytime you have someone being added on, removed, if they have liens at the time of when the deed is executed for them coming off or being added on, those liens now are going to be your problem. So when you go to sell or refinance the property, the liens will come up. So I've had a customer not too long ago where it was a sister who was in title. The property was her brother's and he had been making the payment. She just bought the home for him in her name because she had a better credit score. He was making all of the payments, and literally 2 weeks before she deeded the property over to him, she had a federal tax lien get recorded against her name, and it's almost like $300,000. So now he went to go to refinance the property to put the loan in his name, and he can't do it because at the time of when she signed the deed over to him, she had a lien against her, and now that lien is technically his problem if he wants to get the loan now into his name. So those liens will attach to the property. So you do have to be careful when you take people off, add people on, that their names are clear. And that's something that we can search for. It's a little bit harder when you have a common name, such as Jose Gonzalez. There's thousands of Jose Gonzalez's in Fresno, Madera County. So it's difficult to be able to wean out if there's any liens against that person's name. But, there's probably one Loveneet Bains in Fresno County. If you search my name, you're going to see if there's a lien against me or not. And, you know, there's on the liens, you can see the customer's name, their social sometimes, their date of birth, address. So there's ways that we can pick apart, you know, if a lien belongs to a customer or not. It's always good to do a search though prior to adding somebody on, taking somebody off, just so that you know that your title is still going to be clear. So, any questions about that?
Nothing in the chat. So we'll move on.
So anytime you do a deed outside of a title company, it's called an uninsured deed. So there's no title insurance associated with it. And our job, of course, again, is to clear title. So we have to make sure that if someone executes a deed outside of a title company, we have to go back to the person who signed that deed to make sure that they understood what they were doing. Because there have been instances where people don't realize what is happening. Most of the time you see an uninsured deed in divorce situations where one spouse is to get the property and the other spouse deeds off. We still have to go back to the other spouse and have them sign an uninsured deed affidavit, or the customer can supply their divorce papers to us to show us that they were supposed to receive this property. So we just have to do our due diligence and make sure that we are taking care of any uninsured deeds that come up. We do have to go back to the person who signed that deed to make sure that they understood exactly what they were doing when they signed the deed and transferred the property over. Alrighty, so disbursements. This is a big thing when it comes to closing on a sale transaction. So how do we disperse money? Our company policies require for us to cut one check to the sellers. So if we have two people in title, for example, husband and wife, and you know they're entitled as joint tenants, we will cut one check to them as, you know, they're one seller to us, so that the check will be made payable to both of them. The other way that we can divide proceeds is, let's say that they're going through a divorce situation. We will take a written instruction from them. Then we consider them to be two separate sellers. They will each have their own percentage interest in the property, and we can divide the proceeds however they wish. So if one person's supposed to receive all of the money, we can do that. If there's to be 50-50, 75-25, however they want us to do it, we can divide the proceeds that way too. Going back to though, when I said we would issue one check, we're not going to do, you know, the customer's accounting essentially. So if they want $100,000 to go into one account and $50,000 to go into another account, unfortunately, we're not able to do that. We do have to cut one check. But if they wish to divide the proceeds and split up their interest because of a divorce situation, for example, we can do that too. The other thing with dispersing is if the customer holds title in the name of their trust. So for those of you who take on, when you go to your listing appointment, if you notice that your customer holds title in the name of their trust, advise them to find their trust papers and go to the bank to set up a trust account, because our company policies require for us to make the check payable to whoever is in title. So Loveneet Bains, as trustee of the Loveneet Bains Trust, my check is going to be payable to my trust. It's not going to be payable to me because I'm not the one in title. My trust is. So my trust is the entity in title. You do have to have a bank account, though, set up in the name of the trust in order to be able to cash any checks or accept a wire. We do have banks where customers, they will tell us, just wire the money, I'll see what happens. For example, Bank of America, they will reject the wire and they will deduct $45 for their troubles. So always make sure that your customers are aware that they are going to have to set up an account in the name of their trust. That is something that we discuss when we set up the appointments. It's also something that the notaries reiterate. Sometimes the customers will get frustrated because they didn't realize that they hold title in their trust, that they have to have a separate bank account. So it is a little bit different because, you know, a trust is its own entity. So it's separate from you as an individual. But you know, the check will always be made payable to the trust. That's one of the biggest things to just reiterate to the customers so that they're aware ahead of time. Alrighty, other important things to know. So if you have a customer who is, for example, out of the country and they are buying a piece of property, the best thing to do is to set up for a power of attorney to be used. A power of attorney, drawing and recording the document, that is something that our office offers as a service to the customers. The power of attorney would be specific to our escrow transaction, and can only be used to sign the real estate documents. So the contract, any escrow paperwork, any loan documents. So a power of attorney is a great way to be able to handle for the documents to get signed and to avoid any mistakes. So if you have to use the power of attorney, always consult with your escrow officer so that we can consult with our title officers. There are very specific requirements that we have to meet in the event that a power of attorney is drawn up outside of escrow or the title company. So our power of attorney that we draw, it has very specific language related to the fact that it can be used for real estate documents. There are powers of attorney that customers draw up outside of us that do specifically say that the power of attorney can be used to buy, sell, transfer, or encumber real estate property. So those are the key words that you want to look for when it comes to using a power of attorney. But again, always just send it to us so that we can review it. There's other things that go into it as well. So we'll compare signatures to make sure that the power of attorney was actually signed by the person. We look to see how old it is, because if the power of attorney is 20 years old, it's not necessarily, we can't rely on the fact that what the person wanted 20 years ago is what they want today. So we do have to go back and have underwriting review and assess the risk that's involved with using the power of attorney. But if you have somebody who is going to be out of the area, out of state, out of the country, and they are still in town, when the escrow is initially opened, bring it up to your escrow officer that they will be leaving and see if a power of attorney would be a good option to have, even if it's a just in case thing. So, if the person is going to be going overseas for work, or if they're going to be out of the state and, they have wonky hours, you never know. So having a power of attorney in place just as a backup is always still a good idea. So in addition to us needing it to be approved by our company and our underwriters, if you're using the power of attorney for a buyer, the buyer's lender will also need to approve of the document. And there's sometimes where they will want additional verbiage to be added. For example, they'll want it to specify what property is being purchased. Sometimes they want the bank name and the loan number to be listed on there. And those are things that we can accommodate and edit and to add on to the power of attorney. But just talk to your escrow officers if you ever have a question about a power of attorney and if you're able to use it or not. The other thing on here on the slide is if anyone on title is deceased, when it comes up, always just, let us know and we'll tell you exactly what we need to do. Because if the customer, let's say, for example, myself and Jennifer are entitled together and we don't have a vesting behind our names. So if it doesn't say as joint tenants, then she would technically have to go through probate if I were to pass away to deal with my interest in the property. So having those three words at the end of our names is super important, because if you don't have a vesting, there's no idea what the intention was on my part, if I were to pass away, what I wanted to have happen to my interest. So make sure that your clients discuss with their CPAs or attorneys on how the best way is to hold title. They can come to us. We have different flyers to help them make that determination to see what's best for their financial situation. But always, make sure that if someone is deceased in title, just run it by us and we'll let you know exactly what needs to take place in order to help take care of that person's interest. Going back to the power of attorney, I apologize that if someone is out of the country and they need to have a power of attorney notarized, you do have to go to a U.S. consulate or a U.S. embassy. I have someone right now who emailed me and said, I'm currently in China, so we're making arrangements for them to sign at a U.S. consulate. The U.S. consulate is a 3-hour flight away from where my customer lives, and he was able to get an appointment for next month, 4 weeks out. So we're having to extend our escrow. Luckily, he told me in the beginning on day one when we opened the file that he was out of the country. His wife was handling everything here, and he said, you know, she can sign on my behalf, but we do have to have that power of attorney executed before she can sign any documents for him. So just things to keep in mind. If you have anything quirky that comes up, you know, always don't be afraid to pick up the phone and ask the questions or send an email, because that's what we're here for. And we really do appreciate it when things do come up. You know, we like to be there to help solve the problem and get through it with everybody. Sometimes there's delays and there's things that are out of our control, but we do the best that we can in order to help your escrow process go as smoothly as possible.
Love, I didn't put this on the slide, but what if someone in title is missing? We don't know where they are.
So I actually have had that happen before, where they don't know where the person is. That transaction, it was a for sale by owner that I opened up. Unfortunately, they did have to cancel the transaction because they could not find the other person who was in title. The family did not know that he was put on title. It was from years and years ago. But if somebody is in title, then we have to figure out what happened to them. So if they've passed away, then we would need the death certificate. But if they're alive and we just can't find them, we would need to find them, and they would need to either sign a deed to remove themselves or sign all of the paperwork and become a party to the transaction.
Okay.
Okay. All righty, so does anyone have any questions? I know I went through a lot of information, so if anyone does have any questions, you think of anything after this presentation is completed, you are welcome to call or email me at any time. I'm more than happy to address any questions, even if it's for a transaction that our company is not handling. You know, we're a part of your team, so any questions that arise, we are here to help you and, you know, get through any problems or issues that you run into when you're going through the escrow process.
We have recorded this meeting, so we will be sending out the recording to everybody who registered, and our goal is always to do that the same day, but just in case there's any technical challenges, you can expect it by tomorrow, and we'll, you know, be happy to send that out to everybody. We also have some additional information as far as handouts in Chicago Title Library that are available for you. You can either request them from your sales exec or go to Chicago Title Library and look for them that talk about vesting and things like that. Love, thanks so much for everything that you covered. Is there anyone on the sales team that has any knowledge of anything that we didn't cover that you were hoping we would cover for your clients?
When is our next class and what is the topic, Jen?
Okay, our next class is for new agents and it will be held on Thursday, March 4th. It's our new agent boot camp where we go over what the prelim is and what's expected to be taken care of on the prelim, what to look for, and tips for how to have the smoothest escrow possible, things to look out for, things that we need to get the file opened, some timelines on open to close, and especially that sweet spot between when we hear docs are on the way and when we're able to fund, record, and disperse, because there's a lot that takes place in that window. And so if you have been in the business a year or less, or know someone who is, this is the class for you.
Or you can be in the business a long time and just need a refresher.
That is true.
All right. Change every day.
Thank you again. I'm going to quickly advance to the screen where your sales exec information is. In case you need to reach out to one of your sales executives, we've got phone numbers and emails for everybody on the screen. So I'll leave this up, but thank you again. And that concludes our class for today.
Thanks, love.
You're
Thank you,
welcome.
Loveneet.